Yes. This DJ will kick the floor in 3, 2, 1.
On the troll.
Yes, it is that time of the night. It's the morning, the following day. I can tell you it's happening. Right, yesterday we left you with a lot.
Yeah.
But I'm sure now we are coming back with a lot.
Yes.
Right?
Yes.
So it's happening in that quarter of Ratata. Things are just happening. They keep on happening. And yeah, we had the defense submission. And trying to oppose what would be cross-examining someone on other person's confession. And that is Ndanzi's confession being used in Moses' cross-examination by BALOYI, none other than BALOYI, who submitted as if it was just a small anyana thing.
Small waters.
Until the court said, what do you got to submit? He prepared the whole night. So the others also needed to prepare the whole night because he knew what he was going to do. I guess it was only fair for others to also be given that chance. But greetings to you. And just a reminder, as you come in, please make sure that you press that like button like you mean it, because it's Friday. You've got no excuse other than using your thumb to press that like button and then using it further to communicate as much as you can. If you haven't subscribed, please subscribe. If you haven't became a member, please do so. And just know that membership is renewed monthly for those who do not understand. It is understandable. This YouTube thing is new to us, to some of us. I guess it is older to people who have been using it, which is Americans and the rest. Right?
Yeah.
But we are going to try as much as we can to keep it short so that we give you probably the time that you've been asking for of calling, because you thought we have done away with the calls. No, that is not the case. So, Emily, not going to waste any more time. Let me just give you your platform.
Hi guys, welcome back to the Mzansi Reality YouTube channel. Thank you so much for joining us here again for another live stream discussing what is happening over there at the Pretoria High Court in the Senzo Meyiwa trial. Yes, court resumed this morning. I was happy, I was relieved. I was getting tired of that cross-examination that was dragging for weeks. So it was refreshing. Today was refreshing because we got to hear from different voices what is going on in their arguments. And they had quite strong arguments coming from all the defense counsel. And I was especially impressed by Advocate Nisi and Advocate Mshololo. They delivering their arguments from the bar. It was quite interesting. And yes, Ramasipile and Nxumalo also brought in very strong points, and also they cited very interesting cases to support their arguments. So yes, I was very much entertained. So court resumed this morning, and BALOYI started off by saying that yesterday the state sought to cross-examine the accused on the confession made by accused number 2. The court then asked the state whether this is permissible, and the state then addressed the court as to why it is permissible. Namely, it constitutes executive statements, alternatively hearsay evidence, that it's in the interest of justice to be permitted. And he said that they were referred to the heads of arguments that they presented in the trial within a trial in the matter, and the matter had been adjourned to today to give his colleagues the opportunity to address the court on the matter. And the judge asked Mnisi if he still wanted to address the court. Mnisi said, definitely, my lord, because yesterday we had felt some type of way. Remember Mr. Anonymous about Mr. Mnisi, maybe he should just fold his arms. But being the lawyer that he is, he said that the case is not about him. It's about the accused. It's about Mr. Sibia and Mr. Mncube. He asked for Mr. Sibia to be seated as they address the issue today, because he knew that Mr. Sibia was not going to be cross-examined. And Mr. Sibia, our accused number one, said he'd prefer to stand. So he was standing the whole day. That entire time he was standing. He's a very strong man. I can't stand for that long.
If you've been sitting down for that long, you would appreciate standing.
So he prefers standing. The whole day, I can't. And on top of that, I even heard the judge after the long adjournment was like, yo, you are a strong man. He's been an athlete, a champion athlete. Bengege, bengzofa, or something like that. It was funny. So Mnisi said that he won't take long. It would be 4 or 5 minute thing, but it took long. But I appreciated it. It was from the bar. I find arguments that are done from the bar very refreshing. They are much more organic, in my opinion. Well, he said that what the state is requesting this court to do, he said that it's known as austerity of tabulated legalism. Terminologies. He said, which on its own is unconstitutional and against the principles of the law. He said this is the fundamentally legally flawed and incorrect, and the reason why he's saying that is because the state is basing their request on their reprehension of the legal principle that are applicable in this area of this law. Now, which laws are we talking about? He said we are talking about the executive statement in matters of a criminal case. The common law is very specific with regards to the usage of executive statements in criminal matters. They are admissible and based on common law. However, there needs to be a determination. The reason why he's saying that the state's request is based on their misapprehension of the applicable principles of the law in this area of the law is simply because of what they are saying in their heads of argument. Now, in the response to the 174 application that was brought on behalf of Mr. Mapisa, they said it is therefore submitted that 2 confessions of accused number 2 can be classified as executive statements in the furtherance of common purpose, and therefore an exception to the exclusion of an out-of-court statement of an accused. So Mnisi said that they're basically saying that the statements that are made by Mr. Ntanzi are confessions. That is what they are alluding to. And in the same line, they're also saying that they should be treated as executive statements. Is it possible? Is it possible that a confession can be treated the same way that a statement is treated? Because when you think statement, you're thinking testimonial evidence, right? Which, by the way, this backfires with how those police, the investigators, the cold case unit decided to deal with Bontanzi and Sibia. It's now backfiring on them, because had they been sober, or had they been interested to follow procedure, they would have interviewed them first and then let them go, right? Especially considering the fact that they couldn't even file or couldn't even charge them immediately after their arrest for the Senzo Meyiwa case. They only charged them in October, and then they went and found plastic bags and stuff. So if they had done it the way it's supposed to be done, they would have sat down, did a proper statement, and then maybe let them go and to continue with the investigation. And had they felt like, okay, these people have a case to answer to, we found 1, 2, 3, 4, 5, then go back and hear from them again. But the way these confessions have came about have now caused a challenge, a very major hurdle for Advocate BALOYI there when he's trying to make make a new case to be cited. He's very ambitious, eh? Very, very ambitious. So he's trying to rewrite the law, in other words. So he's trying to rewrite the law to say that confessions can now be used against the other accused. It's quite ambitious, highly ambitious in my opinion. So what I'm trying to say is that had they done this procedure properly by making them take statements, then their prosecutor would be having a statement to refer to now. He wouldn't necessarily need to go to the confessions. Right?
Yeah.
But there's nothing.
Now you want to reduce those confessions into statements.
And that has to be made clear if
those
that's what he wants.
so-called confessions.
He wants them to serve both. He wants them to be confessions and be executive statements at the same time. Being very creative with the law. So he said that their request is based on a legal misapprehension of legal principles that are applicable in this area of the law, because confessions can never be an executive statement and vice versa. It can not be the best of both. He made an example of Albani Bread's slogan. I think it said best of both worlds or something like that. So it is either a confession or an executive statement. The law is very specific. So he said that the state referred the court to the case of Mhlongo and Nkosi versus the state from the Constitutional Court that was decided on the 25th of June 2015, and immediately subsequent to that, a similar situation also arose which necessitated the Constitutional Court to revisit this matter of Kanya and another versus the state in 2017. The decision was made on the 10th of August 2017. The court said the situation with regard to the statement is very clear. It cannot be confused with any other thing. It is determined by what the common law says, and common law says, yes, they can be admissible against each other or against other accused, but there must be a classification of the document that is sought to be used. So it can only happen if that was a statement. It's a different ball game when someone is testifying against the co-accused.
What is BALOYI's angle, in fact, when it comes to these things, calling this so-called confession executive statement? Because I'm just reading about the executive statements.
Okay.
They statements made by someone in executive authority, e.g., police officer, minister, public official, in the course of their duties. It is not a formal legal category in a criminal procedure, meaning that these are things that what Mukhane or Mukhula could have said when he was calling Gininde, say accused number 2 is making or is
making some admissions of what purported to be a confession.
But then you look at that submission again.
Yes.
Gininde distanced himself from hearing what he called
a confession.
He distanced himself from that.
He
didn't want to hear anymore. He left it like that, and then he left it to Mboto and the rest of other people. So then you go on to say that you want to classify now this confession as the so-called alleged confessions as executive statements, meaning you are reducing them to what Gininde says he didn't do. He didn't take any statement. No. He didn't do anything else. He referred to these people to go and fully confess.
Yes.
Because confession on the other side is a full admission of guilt. We have explained it before here.
Yes.
By the accused person admitting committing the crime. And it's governed under Section 217 of the Criminal Procedure Act 51 of 1977. On the other side, defined in statute may fall under hearsay. That's what BALOYI now wants to say. This is executive. This one might fall under hearsay or official statement rules. Laws of Evidence Amendment Act 45 of 1988. So you can have your cake in two ways. Either you fall on a sort of confessions,
or
you say this was just a statement that was made by these accused upon the arrest.
Which will throw away
which would throw away the whole
the
case.
confessions. The entire case is gone.
So now I'm surprised that he wants to submit this. But then he has helped the defense in having arguments towards the end, because now they can argue that even the state is not sure whether these were confessions or what. We had just fought for these admissions to be used as executive statements. Who, if they are sure, would do that? And we're talking about someone who understands law. Why would you feel that these are executive statements then? Why would you feel that you need to apply and say these are executive statements?
Completely botching the case.
Okay, he wants to have his cake in two ways. If it suits him
work
this
like
side,
that.
it's and then no, man, it doesn't
So
work
now
like that.
that we've hit this hurdle, should by some miracle he happens to, or the
win.
yeah,
It
it means
it downplays the whole case.
what I'm more worried about is for the police officers that are studying this procedure and are corrupt. They will make sure that they have both a statement and a confession.
Yeah. But there's a loophole also, because if someone denounce or distance themselves from the so-called confession, and they say you told the person that wrote a confession, like Bombo, you told them, it will be easier for them because you already have the whole so-called statement. So you probably forwarded the same statements to the person who was supposed to take the confession.
Okay. Nisi now said that before this court, that the state says they want to cross-examine Mr. Sibia on these are the statements that the state is saying are confessions that were made by Mr. Ntanzi. Nisi said that he had already referred to a passage in their heads of argument in their section 174 application where they were saying that these are confessions. So the law with regard to the admissibility of confessions in respect of another person is governed by section 219 of the Criminal Procedure Act, and it is very clear a confession cannot be used against another accused person. Nisi said that what the state seeks to do here is to conflate issues, is to muddy the water, which is why he's saying that they are requesting this court to embark on what is known as an austerity of tabulated legalism, something very unconstitutional. So Mnisi said that it is important to classify the nature of that statement, whether it's an admission, a confession, or an executive statement. The state is already saying in the argument that these are confessions. However, they can be classified as executive statements. That is blatantly wrong because the legal principles governing the two sets of statements are totally different. Confessions are governed by section 219. Finish. You cannot take this position beyond that. If it's an executive statement, then yes, then you can take the issue further. What this court needs to do is to determine what are the documents that the state intends to use in the cross-examination of Mr. Ntanzi. Which statements were made by Mr. Ntanzi? Are those confessions or executive statements? These questions need to be answered well in advance, even before the state embarks on the process of examining or cross-examining Mr. Sibia based on the contents of those statements. He said that now, what is a confession? A confession is an unequivocal declaration of guilt. In other words, the deponent of that document that constitutes a confession says, I'm all yours, my lord. You can look at me, but on the basis of this document, you can say to me, I'm guilty. That is a confession, an unequivocal declaration of guilt. Section 209 is also applicable here because it says an accused person is found guilty solely on the basis of his own confession. What is the content of the two documents that were allegedly penned down by Mr. Ntanzi. It's very important to say allegedly penned down. Very, very important. Otherwise, tomorrow or 2 years from now, you will be quoted by BALOYI or the state, even Sibanda. You will be quoted as saying that you said that accused number 2 penned the confession. So you must put that allegedly. Okay? And he said, and this submission must not be construed to mean to validate the contestable statements that are still an issue before court. He said, I'm simply referring to them because of this interlocutory application that is brought by the state. As I'm saying, I'm in no way not trying to validate contestable statements. I'm simply trying to deal with substantive issues as they relate to executive statements and confessions and all issues around them. Now, it is uncontestable that the 2 statements that Mr. Ntanzi allegedly penned before Rapadu and the magistrate Grenier, what are they? Are they executive statements or are they confessions? Can it be said that in the face of those documents, Mr. Ntanzi can summarily be found guilty? Or can it be said that there are issues that still need to be ventilated around those documents? Now, what is a confession? I still remember when I was a prosecutor, he says, Mr. Mnisi, he says they used to refer the court to this case of State versus Goa. Nisi said he tried to look for that case but couldn't find it. Well, the judge asked him as to how he could not find it or the authority, and Nisi said that he was let down by his system because he's using an old-fashioned system. Yeah, you can tell with the lawyers there, they are not on to the electronic type of way. They still prefer pen and paper, good old-fashioned pen and paper. Okay. I have to also admit, Mr. Anonymous, I prefer pen and paper too. Maybe it's because I've never liked working with... It's tough. It's tough to retain information. I feel like you retain it better when you write it down. So the state versus Goa, he said that it seeks to differentiate what a confession is. And Mnisi also referred to another case of state versus Lekwareni, a matter from the Witwatersrand Local Division, WLD. He said that there he thinks it's where Judge Mokhatling started as a judge. Well, the judge denied this. He said, no, I started somewhere else. Okay. So I felt like maybe even Nisi was trying to break the ice there. What did you think? After yesterday and what happened yesterday? Hi, Connor. Life is tough. I don't think it's hard. The way they just carried on like nothing happened yesterday. Hey, Upelo kenitwa. Upelo. Nisi said that to some extent he tried to sort or try and demonstrate what a confession is, but in broader context of what a confession is or an approach in determining whether a statement constitutes a confession, they're saying that an objective approach must be used. You don't look at one thing and make it a judgment based on it. In other words, the entirety of the document must be considered. Now back to the main question. These statements allegedly were made by Mr. Ntanzi. What do they constitute? Do they constitute a confession or they constitute executive statements? He said, I may submit, my Lord, without any fear or contradiction or appraisal that prima facie constitutes a confession. And it's a confession. The story ends there. Because they cannot be executive statements. They therefore cannot be used against the other accused persons because their position is governed by Section 219 that says that a confession by one person cannot be used by the other person. Then the state's application on those bases stands to fall off. Which should also explain why allegedly Ntanzi allegedly wanted to turn him into a state witness. Because had they done that, they were going to be able to execute this.
Why? Because
he would have issued a statement that implicates the rest of the accused.
But this should put a question mark from the judge's point of view. you went to a trial within a trial because you thought you had what we call confession. So now you are coming back. You want to change that. You want to change that. Then the question is, then why did you arrest Bontans?
That is the question.
If it's not because of that confession, then what was it? Because
What
now
were
we
you
are
arrested
reducing the
based
so-called confession into statements. You couldn't have arrested them on a statement. You arrested them because you thought you had what we call confession. And we went to a trial within a trial because we wanted to have this mini hearing inside the trial to decide whether certain evidence is admissible, right?
Yes.
But if you look at an executive statements, they are not made by the accused. They could be affidavits. There could be anything that is written by an authoritative person on behalf of or whatever based on that investigation or a report. It can be anything.
Yes.
You know,
Yes.
they are not admissible as confession. There is no confession there.
Well, the judge
So
says there
now
is.
you want to revert back and go back and say, change it now.
To
Move it
executive
from section 217, put it to section move it from section 219, put it to section 217.
That's basically.
So you are
what's
saying,
going on.
yeah, you are agreeing with Bontans. You're saying they were right in saying that they didn't write anything there. They were just told to sign.
Yes. Which would completely throw off the entire case.
You are admitting that you actually orchestrated everything that is there. You wrote it as you are writing affidavit and everything else. You are literally saying that by actually going through this process of submissions, you are literally saying, yes, you were right.
You were right.
You cannot
didn't
have a
write those
trial within a
confession.
trial for a statement or an affidavit that was written by
No.
you can't.
No, you have it for a confession. Yo. Hi, God. So Mnisi said, I would therefore submit on the state's own concession in their heads of argument that these are confessions. It should have actually ended there because you cannot have a confession and an executive statement in the same line. No, it's either it's an executive statement or it's a confession. And he said that would be his submission. It was now Ramosepele's turn, and he said that he slept in the wee hours of the morning.
Indeed. I think he had a lot to write.
Yeah. Well, the judge said, yeah, please. Please. And then Ramosepele said, trying to bring this excellent document before court. Well, he said, my heads, I gave it the heading common purpose or executive statement exception, whether the state can cross-examine one accused on a confession of the co-accused. Let me say, he did pour his heart out into this document. So I felt kind of guilty not covering some of the aspects and points. So I did, guys, because I just saw the passion. I know following it was hard because it's so deep and it's full of legal jargon and everything else. But I was like, this was a huge effort. I mean, and he also brought out points that were different from the ones Mnisi brought up, like this whole thing of common purpose, right? it was something different. So Ramasipili said, we say by way of background, my lord, that the state is busy cross-examining Mr. Sibia, and in the process of doing so, it has signaled its intention to cross-examine Mr. Sibia on the statements allegedly made by Mr. Ntanzi. The essence of the state's argument, as understood yesterday, although today they have added the second part, was that this was an executive statement made in furtherance of the common purpose. Now today they are adding the second option that if it is not an executive statement, then it should be admissible against the co-accused in terms of the Hearsay Evidence Act 45 of 1988. Now, Ramasipili,
it's like, isn't it executive a statement is actually part of the hearsay? So it's like you're submitting one thing in one.
Yes.
Like you are still doing the very same thing.
Yes. It is hearsay. It's part of hearsay evidence. Well, Ramasipili read his authority, and he said that as a preliminary, executive statements are statements that are made by one participant to a conspiracy in the furtherance of common purpose, and the rider is this. While that common purpose is ongoing and the executive statements is made in the execution of that conspiracy, this executive statement, if indeed they are executive statements, they are admissible. The statutory framework, the admissibility of a confession and admission in the South African criminal procedure is governed by Section 217 dealing with the admissibility of confessions by accused, which states that a confession statement by the accused is admissible against the maker, that person. And Section 218 deals with admissibility of facts discovered by means of an inadmissible confession or statement. Section 291, which is specific in this matter and deals with the confession not admissible against another. And it explicitly states that no confession made by any person shall be admissible as evidence against another person. And 219A deals with the admissibility of admissions by the accused. Ramasipili said that with respect to Mr. Sibia, accused number 1, the state has tendered this alleged statement as a confession in terms of Section 217 of the Criminal Procedure Act. The court has ruled that the statement should be admissible as evidence in the trial within a trial. And with respect to Mr. Sibia, the state tendered the alleged pointing out and an admission statement, which also fall under the Section 219A or 218. And with respect to accused number 2, the state tendered 2 alleged statements made by him as confessions. And these 2 were ruled as admissible evidence in this matter of Section 35(3) of the constitutional framework, which guarantees every accused person the right to a fair trial, which concludes the right to remain silent and not to be compelled to leave self-incriminatory evidence. The case law he referred to was S versus Ndlovu, and it's from the Supreme Court of Appeal. And Ndlovu temporarily widened the admissibility by allowing one accused extracurricular statements to be applicable to other accused in terms of the Hearsay Evidence Act. The court in that matter said it invoked provisions of Section 31C of Hearsay Evidence Act 45 of 1988 and allowed the extracurricular statements of one accused to be used against the co-accused. And there were subsequent cases that followed Ndlovu as well in Supreme Court, and he said they named them, and they are S versus Ralekukwa, which is from 2008, Supreme Court of Appeal. There was also the case that followed Ndlovu, which Mausha versus State 2007. All South African reports, and Ndlovu offers no guidance as to how the receipt of the extracurricular admissions which it allows should be approached at common law for the exclusion of what role, if any, common law safeguards should play. Now, he said that in the Litakov and others, they say that Ndlovu's judgment was inconsistent with the common law. The common rule that was not only an aversion to the admissibility of hearsay evidence, but it was developed because of the inherent dangers of permitting the use of extracurricular statements by one accused against another. It recognizes potential conflict between the interest of the accused persons Furthermore, a co-accused cannot be compelled to testify. The common law appreciates that fair trial rights, including the rights to fully challenge the state's case, may be hampered, and in glove with the provisions of Section 3, Subsection 2 of the Hearsay Act were glossed over. The statement must form part of the data in the commission of the crime. An example found in Hoffman and Zephyr: if A, B, and C are engaged in a common purpose, it will be admissible against B and C, and that was validated in the matter of R versus Mayet, 1957, and also as S versus French Baytac. This also extends to verbal declarations, he said, made during the commission of an offense where perpetrators acted in cahoots with each other. Ramosepeli quoted another USA case of Kruletic versus USA 1949, and he cited with approval in Hong San versus USA 1963, while the judge said that Hong case specifically was stated in State versus Zuma case. And Ramosepeli said, to ensure clarity, it is important to stress that common law exceptions continue as part of the legal system in S versus Mhlongo and Nkosi. As he quoted above, the Constitutional Court was asked to decide whether the common law rule permitting the admission of statements made by an accused outside of court in furtherance of a common purpose would violate the Constitution if used against the co-accused. But the Constitutional Court found on facts that the matter was not ripe because the issues were not raised. So on the facts of that case, Ramosepeli on the issue of conspiracy said, in the case of Letako, the court held that furthermore, either than when one is dealing with the veracious admissions or statements made in furtherance of common purpose, neither of which are applicable in the present case. He said it's difficult to see how an accused extracurricular statement can bind another. He said, now we deal with what Mr. BALOYI seeks to do, which is to be allowed to cross-examine Mr. Sibia on the alleged statements made by Mr. Ntanzi. And he said, my lord, I must say I was taken by surprise yesterday when Mr. BALOYI stood up and said that he wanted to refer a statement to Mr. Sibia, which is a statement alleged to have been made by Mr. Ntanzi, and he wanted to cross-examine him on that. He said, we've had a trial within a trial in this matter, and at the trial within a trial, in respect of Mr. Sibia in particular, when that statement was introduced, the state indicated that they are introducing the statement so that it is binding against the matter. At no stage were the other co-accused recognized to say, should the court admit this statement as evidence, then the rest of you, this statement is going to be applicable to you. Then it will give the other co-accused the chance to challenge or to say yes with the statement made by Mr. Ntanzi. Now to come up in cross-examination and say, now that the statements are admissible, I'm going to refer you to the statement to bind you and to bind the other co-accused because this is an executive statement. He said, I submit without contradiction that this is not an executive statement, and I'll show why I say this is not an executive statement. And I'm also not going to give them a classification to say that they are, because the court has not indicated, yes, whether they are confessions or admissions. So I say I'm not going to be brave to say that this is a confession or this is an admission. Ramosepeli said that there was no lease to say, Mr. Ntanzi, once your statement is admitted, I'm going to use against Mr. Sibia and the rest of your co-accused, so that their lawyers could make the necessary legal routes to protect their clients' rights regarding those statements. Ramosepeli said that the state never did an application to court where they said that they wanted to make an application that hearsay evidence and espouse that hearsay evidence clearly to be admitted against the case, the accused, before court. That was never done. The bus has already passed. So according to Ramosepeli, which I heard even the judge inquiring from Advocate BALOYI after the adjournment, just before they adjourned, he was asking about this point. That's when I started noticing that, yeah, Ramosepeli did do a lot of work here. He left them with too many question marks that they're going to have to think about. Because I was expecting that after Advocate Baloyi was done, he will have made his decision, but he's choosing to sleep on it and he's saying he'll be back with it on Monday. So I must also say that, it was some powerful points that Ramasipili made there. So he said that now the submission that we are making, that this application by the state must fail. The statements that the state wants to cross-examine Mr. Sibia on were made long after the offenses were committed. At the time the statements were allegedly made, the objectives of the alleged conspiracy submitted by the state were no longer capable of being pursued. He says such statements are narrative statements because they are narrating past events after arrests. After arrests, any statements made is not an executive statement but a narrative statement. So he's even cancelling this concept of an executive statement to say that according to what he's cited and read, it's actually not even supposed to be called an executive statement. It's supposed to be called a narrative statement. It was made after they got arrested. Interesting. So whatever there was to introduce cannot be allowed because these are narrative statements. If indeed they were made by Mr. Ntanzi and made by Mr. Sibia to incriminate the makers themselves, but not their co-accused. Ramosipili said, I want to be like Mr. Mnisi to say that if the statement was made by Mr. Ntanzi, I am in no way saying he made it. I'm saying in the context of this argument because tomorrow I know it will be quotes to say that during the argument on the 30th of the 2000, Mr. Ramusipili stood and said, you made a statement.
Hey, they must correct themselves. Papi Baloyi is waiting.
So Mr. Ramasipili said, so I don't want on the right side, when the arguments come later, Mr. Ntanzi is held to the contents of the argument that I'm making specifically for this application, and then I'm called never, ever. Everything never, ever. Hey, they said you never went to Joburg. Your legal representative, Mr. Sibia, said you never, from the period of 2013 up until 2015, you never went to church. Yes, I'm hearing you and what you're saying, but your legal representative said you never. That was a feeling. He was in his feelings. I don't blame him. It's very annoying. Well, Ramasipili said executive statements are not made by police officers. They are made to co-conspirators. And for those reasons, my lord, I say the application by the state tends to fail. No, but it was a powerful submission. I don't want to lie. When I was listening to it, because when he reads, he doesn't read like fluent. So you follow. It's hard to follow. But when I reread it, hi, Chapelang tate Ramasipili matsoho. Chapele matsoho. Ay, this was powerful, you know? Like when I was listening, guys, I don't want to lie, I was so bored. I was like, I'm not quite getting it. But then what gave me a hint was when the judge was asking Baloyi, and I could see that a lot of the questions were coming from Ramasipili's submissions. Did you notice that? Well, after the short adjournment, it was now Advocate Ngumalo's turn, and he started by thanking the judge for giving the time to prepare their heads of argument. He said that he's still awake from yesterday. Well, the state versus LinkedIn and others, 11th of August 2025. So there's actually a much more recent case dealing with such a matter in the Western Cape. That's very interesting. So Ngumalo said that he found it useful for this case. Ngumalo said this whole process emanates from his heads of arguments, which they filed on the 13th of August 2025 for the section 174. If one would have responded much earlier, then they would not be finding themselves from what they are finding themselves in today. I don't know what he meant by this. It flew right over my head. I didn't catch it, guys. I don't know what he's saying. Well, Ngumalo said that he was also surprised yesterday because from his experience as a state advocate in the Eastern Cape and KZN High Courts Division, he has not come across such a procedure. Isn't that interesting?
It's a learning curve.
So manje kuthiwa the law, Advocate BALOYI is attempting to rewrite the law, to cancel, to rewrite it. So Ngumalo then said the defense vehemently objects to this as it violates the accused's rights in terms of Section 35, subsection 3 of the Constitution. The state alleges that the statements made by accused number 2 is an executive statement as it is made in the furtherance of a common purpose or conspiracy. He says it was on the basis that a trial within a trial was conducted for the admissibility of a statement made by accused number 2 before Magistrate Grenier. The trial within a trial was conducted in order to determine the admissibility of that statement, as accused number 2 contested the admissibility of that statement on the basis that it was not made freely and voluntarily but under threat of assault. The court nevertheless ruled the statement was admissible and it could be consequently used to test the veracity of the contents. Ngumalo said, I submit with due respect that this is an attempt by the state to force open the door for the admission of such statements as executive statements against the co-accused, and this could undermine the integrity of the court and our jurisprudence, and it should be discouraged at all costs. Ngumalo also covered the common law exceptions that Ramusibili covered and also the conspiracy that was covered as well by Mr. Ramusibili. So he also quoted Section 219, a confession of another accused cannot be used indirectly against another accused. Ngumalo brought up this Snako issue as well about Zungu saying that he was with Gwabeni and Gwabeni told him that the firearm was used to shoot Snako. It was thrown at some river, and then the judge asked why did they not put this to Zungu while he was testifying. Ngumalo was actually reminding the judge that they actually did. Nisi did, and he also did. And he went back to the record. The records is from the 11th of September 2023. It was quite lengthy as he was attempting to go through it. I think it was 4 or 5 pages, but he did state that it was addressed. And I remember it being addressed. So it was absolutely shocking when the judge said, why didn't you put this to Zungu? But they did, because even the news on social media came out as Zungu was testifying on the stand that actually Snako is not the way that it's being narrated by Zungu in that court. Well, Ngumalo said...
Talking about Snako's shooting.
Yes. Yes, so Ngumalo raised it today, even in this matter, to say that the judge told them when they were recently now just raising it, he told them that why didn't they raise it with Zungu? So he was telling him that we raised it with Zungu. We did. So Ngumalo said, I'm raising this because since one would want to say that since I have indicated before this court that the evidence of Zungu was that of a single witness, there was no corroboration. And when you think about it, yes, a single witness with no corroboration. None whatsoever.
Yes, there was none.
None. So, but one will find that since Zungu had questioned Gwabeni about the revolver, then that amounted to corroboration by implication. All right? And the state didn't bring Gwabeni to come and support this.
No.
So the judge said, who says that? Well, Ngumalo said that for the court's judgment, that is why I'm raising it now. And the judge said, no. It's a peripheral issue. Zungu is a single witness. We all know that. Nxumalo said, I just wanted to highlight that this was done under cross-examination. How siyabonga Nxumalo, siyabonga. Siyabonga. Nihambe kanjani, nibambe kanjalo. Keep correcting all these misinterpretations. Especially if they are big, correct them. Well,
And it's very important to say the least, because
yes.
you claim that this is your evidence as a single witness that is not corroborated. You claim that there was a shooting that happened prior to that. So you ask a question. You yourself, in fact, in trying to corroborate your story, you are actually found to be lying.
Which is a red flag.
It is a red flag.
Major red flag.
It's a very big one that Nxumalo raised. It's a very
it's a tool
very
to
big
discredit
one.
Zungu as a witness. It's important.
And before
it
even
be
his father
misconstrued.
comes.
Yes.
Because that is going to come now.
Put a nail.
Yes.
Izoyenza nje.
Because they should ask the father if he knows about that shooting.
They should. Well, Mshololo said that she will also address from the bar. She did not write the hits as well. Mshololo said generally the confession in terms of section 217 is generally admissible against the co-accused. As versus Moleleme, Concord decision by Nkabinde, it's a standard rule which confirms the rules of the provision of the criminal procedure and the constitutionality of the provisions that use of a statement against the co-accused is unconstitutional. So she said in this case, this court has ruled on the admissibility of the statement that is in issue, and when the state introduced this statement, informed this court that they intended to introduce the statement which was referred to as a confession, and the other was referred to a pointing out. And when a ruling was made, this court was guided by the provisions of Section 217 and Section 219 of the Criminal Procedure Act, and even the proceedings of a trial within a trial proceeded along those applicable proceedings of the law. At no stage wherein it was indicated that such a statement were the executive statement, and even when the ruling was given, it was not given that this statement is ruled admissible as an executive statement because it was not trialed as such. And the trial within a trial was not done for the purpose of admissibility of an executive statement.
No.
So the submission has been made by the state. She quoted Hlongo and Nkosi case, and she read where it said that at common law, there is an exception to the exclusion of extracurricular statements of co-accused if the statement constitutes an executive statement. Mshololo said the main issue to be decided by this honorable court is whether the statement made then she said, let me not say the statement was made, because one day it will be said, I said the statement was made. Advocate BALOYI was catching strays today.
Yeah, he's been doing that to them.
Today was catching strays. I was like, yo. The judge asked Mshololo, who will say that? And then Mshololo said, the state. Yes, the state will be saying that. So she continued to say whether the statement contained in Exhibit GG, Exhibit FF, respectfully before this court constitutes executive statements. If they are no longer the confession, they are now executive statements, then this case is applicable. But if they remain a confession and a pointing out, then it means that this case is misplaced, because the statement that is before the court is not an executive statement. In other words, the state is doing what is called trial by ambush. Which is what I've always felt since day one with this case. The defense has been ambushed. One of these lawyers, after this case, they will be cooked.
They've learned a lot.
They've learned so much. He said introducing a statement as a confession, as a pointing out, then after the state's case has been closed, the state makes submissions that such be referred to as an executive statement. She said that there's a huge difference between the two statements. She said she will highlight a few differences between the two statements. A confession is made before a peace officer. A pointing out is made before a peace officer. An executive statement is not made before any peace officer or a magistrate in terms of section 217 and 219 respectfully.
It's more an operational report of what happened.
She said, the point I'm trying to make, my lord, is the difference between the two and the circumstances under which these two statements will be made. An executive statement is not made before a magistrate or a peace officer. That's the difference. Mshololo said that had we been informed from the beginning that these are executive statements, the accused persons would have defended themselves differently and appropriately. And as a result of the misplacement of this submission, the accused's rights to a fair trial had been violated. Even if it has not been violated, but it would have been violated if the court allows the state to use the statement contained in Exhibit G, G, FF, and HH against the co-accused. Their rights to a fair trial will be violated, and it will render this trial unfair. And also, their rights to equality will also be violated. Mshololo said, as a result, it is my submission that this court should not allow the state to fish, because the state is now saying it's a confession at the beginning during the trial when they say it's an executive statement. Alternatively, it's a hearsay evidence. She said that we are running parallel regimes. And which ones do we need to defend? The status of the evidence that is represented before court is very crucial so that the accused would be able to defend that evidence appropriately. The problem is that it is not defined properly. The classification of evidence that the state is intending to lead or that the state is leading. At the end of the day, the defense will be expected to make submissions on the admissibility of such evidence for the purpose of conviction now. If the evidence is introduced as a confession during 174, it is introduced as an executive statement, then our argument it is not clear as to what is it that we have to defend regarding the statements when we are doing the assessment of evidence. She said, I submit that these three statements, as they have been ruled, do not amount to the executive statement. The case of S versus Mhlongo and S versus Nkosi 2015, the exception that the state is referring to is misplaced because the extracurricular statements are not executive in nature. Therefore, the exception is not applicable in this case. Because the statements we are talking about are not executive in nature, they were not meant for executive processes or purposes, and the intention thereof. The state indicated that those documents were made under the provisions of Section 217 and 219 of the Criminal Procedure Act, and therefore the exception that the state wants to rely on does not apply to the statements that are before this court, and they cannot be used against the co-accused. Mshololo said that there are laws of governing the admissibility of these two statements, the executive statement and the statement made under the provision of Section 217 and 219, and it cannot be tried vice versa. The usage of such a statement as well as is governed by the Criminal Procedure Act. The usage is protected. You cannot introduce a statement as a confession and then want it to be used as an executive statement. Mshololo said, therefore, it is my respectful submission that the state should not be allowed to use the statement on Exhibit FF, GG, and HH against the co-accused. They will suffer an unfair trial. And she said those were her submissions. Also, very impressive, especially as it's coming from the bar. They made it look so easy, like a walk in the park. They've gotten sharpened by this case. I don't want to lie.
Yes.
So Ngumalo also talked more facts after Mshololo was done. He brought up the case of Shabir Sheikh, who still remembers.
Yes, Shabir Sheikh.
He said the facts of the case of Shabir Sheikh may be totally distinguishable for this case because it deals with the arrest of accused number 2 on the 16th of June, and he made a confession before a magistrate on the 24th of June 2020. His statement deals with past events that have occurred on the 26th of October 2014. So it does not deal with any past events. It deals with the contents of the facts and the activities that were detailed there. So one must not be misled affected by this case as having found support in the proceedings. The reason why he used this case is because Advocate Baloyi had also used it to support his argument. So Baloyi briefly responded after the long adjournment to the arguments that had been raised. Honestly, Mina, by this time I was tired. All I heard was blah, 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 blah. I couldn't contextualize what he was saying.
Miss Shololo said that they must not be accepted. That's when he's reading down. And then he keeps on highlighting things with his mouth. Be accepted.
When he quoted a case from 1939, Rex versus Miller. And it's in the division. It's a divisional case. It didn't even reach Supreme Court of Appeal, Constitutional Court. It was in the division. From 1939.
What he
says that it says that the acts and declarations of one conspirator are admissible in evidence against another, provided that they are act performed and declarations made in the furtherance of common purpose. Under this rule, admission made by a co-conspirator after the purpose had been completed, consisting a relation or narrative of some part of the transaction, had been held to be inadmissible. Vele ngabona ngokuquote le case yase 1939 ukuthi hayi bokushubile.
He has no issues.
Hekushubile.
Let's press the like button, guys, please. Let us play with it.
Now, he said that this was according to Zungu's testimony. He talked about the accused number one climbing a chair and saying that yes, and seeing both the accused coming and going from the Basutung hostel. So that coincides with the confession, because in the confession...
So therefore, should the confession be allowed to be an executive statement because of that?
According to his
Why
argument,
didn't he use Zungu's statements to actually question Mose on whatever that he wanted to question him, which he did, in fact?
He did. It's not
Why
enough.
does he need the confession or the so-called confession of that?
Nathi manje ufuna ukuqinisa manje. Ufuna ukuqinisa icase yamo. Okay, guys, it's a wrap. I'm done.
Let's hear what you guys have to say.
I'm done. I'm gonna promise to keep it short. I'm done. Please
Let's hear
call
what
in
you guys have to say.
and tell us what you think about the developments so far. If you have been following the case, I want to hear what you think. How did you feel about that long, never-ending cross-examination? And how do you feel about him also wanting to now use the confession of accused number 2 Ntanzi against accused number 1, Mr. Sibiya? He's trying to write his own case law, trying to go out with a bang, you know?
Yes.
That in the Senzo Meyiwa trial, I actually rewrote the law. I did, you know, these big things to add to the CV. You understand?
Under circumstances. Let's see what you guys have to say as you press the like button. Now we wait for you guys because Mzansi, hello.
Good anonymous.
Yes, sir, how are you?
Yes.
No, very well, very well. How are you, Sis Emily?
I'm good. How are you?
Yeah, no, keeping on. Yeah, no, it's been an interesting week. When somebody is stuck, really cornered, and he's really tried to pull all strings, but Moose is stuck in there, and the story is quite consistent, and he's really struggling to bring him down.
Yes.
But then, well, again, I will allege here, like what Mr. Anonymous, you observed the emotions when it's all a game, a play. usually when there is something that needs to happen, the emotions are so high, and then whatever, really making sure the defense is sort of cornered, and then be afraid to react, allegedly. Then you get again the coincidence of things. If you consider that this so-called cross-examination on the statement granted, it was something he wanted to do there and there. Then the judge is saying, is that permissible? All of a sudden, the application comes through and it's not clear that it's an application. And I suppose it was a hope that the judge was going to just say, okay, go on then.
Yes.
But then I suppose the way, it felt as if like the defense, it was going to be sneaked in, and the defense will not realize that it was an application, and the judge was going to allow him to go ahead and whatever after quoting whatever the laws. But it was funny that when he tried, the judge goes, is that permissible? Is that allowed? All of a sudden he's got this prepared sort of heads of argument. And the other one, I mean, what I found interesting is the way the defense went out there and pulled out a lot of references to other cases that they were really wanting to defeat even the judge on their heads. The only issue now is the judge really pulling out Ilokuzeni from BALOYI, trying to assist him at the end. How about this? How about that? And I thought he was presenting his case. You are meant to go and make your judgment. It's not on him to start trying to prompt BALOYI to come up with countering the defense. Really, it was more like the judge was now working with the prosecution to put together the arguments against what the defense had put on. So just wondering what Monday looks like, whether he will have gone and sort of researched as well and come up with what his brothers have said and whatever, and then pull it through, because I think he goes, and once you see him taking it away, I think this is allegedly. I think there's some research that really happens to come and say, my brother has put this, my brother has said this, or whatever. I'm just concerned. There are some things that is just ruled on the bar, because the presentations were quite good with the defense, and the worry is that maybe, and some corners, this is allegedly. And the other thing, this is me again running and saying, the other thing, the emotions, Muzi really pushed back that the judges, if he is working with BALOYI, he was cornered. It's a difficult one really to back the state and then come up with whatever, because everything was really pushed back on.
Yes.
And BALOYI really seems to be struggling, and you'd hear him start to push on something, and you think maybe we'll get to the end of it with some fireworks. It just all fell so flat, and I felt disappointed for him really, because he's holding onto a dead horse, if one can put it that way. Anyway, I'll allow others to also express their views. Thank you for the opportunity.
The young ones would say he was cooking, but the stove was off.
This is it.
No, thank you. Right, the calls, the lines are open. Share those opinions here now. This is the time. Press the like button and share the opinion here. This is the time. You guys have been asking us to open the line. The lines are open. The number is
this is why
071, right?
Yes.
153.
Yes.
7006 for WhatsApp or for direct call 071 153 7006. That's the number. So keep the calls coming. Keep the liking.
Yes.
Keep the subscribing.
Yes.
And then also, if you can, join the membership. Right? Sila Last Corner. We are here for you today. Told you we were tired. We are still tired, but it's Friday, man. Why not?
I think my frustration was Advocate Baloyi's cross-examination. It really...
I foresee BALOYI submitting more before the judgment.
Because
they didn't seem to have a proper ending. So
the judge was also giving him clues of more cases to go inside.
So you do foresee people
on Monday,
coming.
He's
and
going to
the funny part is gonna be then when the judge is using those cases to actually give him a victory here, which will be a really I think a downfall of both of them. So let's hear what you guys have to say. What is your take? Nibuye nhluphe lapha ngoba nibengisafona kade kusho nina nethi hey
sicela ukufona bathi manje anisafoni
manje ansekho anisatholakala. Press the like button though. You can call through WhatsApp, you can call through just direct number if you have airtime, minutes, anything. The number is available there, 071-153-7006. That's the number. While at it, please, for people who are coming in, press the like button. We are chasing 200 likes. That's what Mtozi Slanga is saying. We are chasing 200 likes. We are here at 185 and probably we will chase more. Siba? Sesitubile niyasincisha amakhoza hayi siba funa nzima siwesikhathele unzima go through that. Uyabona today we are even more like you can tell
we are lighter. You can tell about today was proper stuff at the courts. I was finding myself in the wilderness. How am I gonna get through this?
Yes.
And the thing about it is that I can't rob it because robbing it creates an opportunity of not understanding what is going on, and then the next thing, everything is just flies through. Even how the previous caller just described how it was like they were trying to slip in this cross-examining of Sibiya about that confession.
Hello. Mzansi, hello.
Njani?
Siyaphila njani mfowethu?
Angiyaphila futhi.
Yebo futhi.
Usayimuli kuphi?
Yaphila njani?
Ngiyaphila. Hey, hayi Ramza little big Ramza ngibusisile. Ucala wakhe la BALOYI wathi ungasifundzisa. Yayibona. Namuhla wamtshela wathi never. Yabona. Yeah, never ever. Lapho khulu kwatile ngiyabona ukuthi la musla kahle kahle kube bebaseground ngikangamshado komthayi. Hayi kila ukuthi BALOYI unemanga kakhulu. Maye abasafuni lokho.
Yeah.
Yeah, lento endibhlungu phela lento leya and lento isebaleni futhi mara babhizi benta so amara right vele abalwe vele njalo isikhathi sokudlala siphelile asikhale
mediphele lento
ya straight yasichwele phambili kubanjwe labo le course vele babambiwe ya singivulele nabanye ngibonge kakhulu
siyabonga kakhulu futhi siyabonga
never ever
awuke ngasetelele ngothola sibhakela BALOYI Okay, bye-bye.
Thank you. Bye-bye. Right. Umnandi uzwa abantu becholo befona behave. It is nice when the court is just courting, doing what the court is supposed to do.
Normal stuff that we're used to.
Not
following evidence for 3 days only to hit a puncher.
The Ramsipir was making sure that it doesn't repeat that thing of saying you never ever came to Joburg.
No, it's like a little bit of grace for him because he was consulting with Sbia.
And he's not Zulu. He's not Zulu.
Ramsipele hasimu Zulu. So something there might have, So to see Advocate Baloyi like hammering on it like it was a fact, he completely even dismissed Bia's testimony because in Bia's testimony he did not say never.
Zansi, hello.
He said sometimes.
Zansi family.
Hi.
Hi, sir. How are you?
How are you guys doing?
We're doing great, man. Doing great. How are you, Nessa?
Well, we're doing okay. Besides getting older right now.
Yeah.
First thing, I think maybe, remember long time ago, SAPS used to be called SAPF Police Force. And then they changed it to say, no, it should be Police Service.
Yeah.
I was just thinking that the judges, they should stop addressing them as my lord. Because, the word my lord has too much power on somebody. Like, I think they need to be addressed differently than my lord. Because I was like, it just gives a different vibe, especially if you see what was happening yesterday. You still have to address the guy who tells to shut up and sit down. You still have to say, my lord. I feel that has to be changed. They should be addressed differently.
Yes.
Yeah, they should be addressed differently. And I think the judge today had a different energy because he realized, because he brags about never being appealed successfully, and he knew yesterday he gave them the best point to appeal his case. If he were to convict what happened yesterday and what he did, that would be a very, very good point in appealing what he did. Because yesterday was a big, big miscarriage of justice. Yeah, it was broad daylight. You don't need to study anything here. You don't need to study anything. You can just see right there that this is miscarriage of justice. And whoever is training or maybe mentoring Sevilla, the person should have a big sit down with Mr. Ntanzi and tell him, you answer what you know. What you don't know, you don't have to answer. You don't have to keep explaining. Do not go to an extent to try to convince Baloyi. He don't care about you.
He doesn't care, yes. He doesn't care.
No, he don't care.
Flat answers.
Yeah, just answer. Yeah, if you have to break his heart, go ahead and break it into pieces. Because he don't care about you.
No, he doesn't care.
No, he don't care. Yeah. No, thank you guys for taking my call.
Thank you for calling.
Thank you, Sebong. Thank you. Right. Keep those calls coming. Keep them calls coming and press the like button. It's there, up there. Just make sure you press it. We are now officially chasing 250 likes. And the calls, the lines are open. Mayane Dangane, this thing of my lord is wrong. I like I always say, because it makes them to be lions in the court. Yes, that's what Mayane is saying.
It should be scrapped.
You were saying, true caller, especially old people like Rata, he is thinking he is the real damn lord. The demigod. That's what people are saying. That's what people are saying. So, aswatitela amakholo bafowethu osani in Linden. Lola, it's good that he does not. Okay, he's talking to Caesar here, Lord. Amakholo ke wona aphi bafowethu phela kade nesifuna. Victor Matsunyane saying, hi family, we are 205 likes going to 300. Yes, chasing that 300 while we wait for your calls. Yes, thank you, Victor. Thank you. We appreciate you for reminding us to push for the likes. Press the like button, guys. Swazi Shabalala. Hi, Emily. I see you missed the part where Rata admitted that it was an error on his side when Advocate Ngumaro reminded him that they did not cross-examine Zungu on Snako issue. I think that's what you wanted to say.
Yes.
Yeah, but yes, it does not matter. But the record at the time was reading that they did not, and that was done on purpose. It's never, this record thing. Baloyi made me realize that this record thing is very important.
It is.
So that's what the Rata was doing, in my opinion, making sure that the record remembers that there was no such information that was given or asked about Snako. Now,
and Ngumalo fixed it.
Ngumalo fixed it.
So whether he agrees or admits, or I honestly do not care.
I think that's why Emily skipped that part, because
It doesn't make a difference.
we're not here trying to make him look like a saint
No.
or trying to look like
He will disappoint you.
Cindy. So
I've had
TL,
hope.
the
I've
judge
had my
now
hope crushed.
knows that this case is on the spotlight. Everyone's eyes are on him. He's really struggling to be fair. That's what Cindy so is alleging. Right. Robert Matlala. So the judge is openly assisting the states. Yes, I've seen that a lot on TV for everyone to see. Yes, I've seen that a lot.
But to niggas is scope during the people, allegedly.
It happened. I was also,
It was the end. It got awkward. Like, you are giving him cases.
Hey, when we are highlighting them. Guys, keep the calls coming. 071 153 7006. That's for WhatsApp and for direct calls. Chadi Molantwa at the morning. We are waiting for your calls. So as I'm doing that, I'll be doing something else. Mbali Biela family. Hi Mbali, hi Ndabezit. I'm Tozi Slang. Likes. Please remember to like the video. That's our moderator. Spamandla 76 Molweni family Molo Spamandla. Chris Niwo Sihlako Nebza Uti. Good evening family. We wait for your call. 071 153 7006. Number is not difficult. Lawrence Buthelezi siyabonga ukuthi ukhona sawubona back and sibonge ngafethu those who are giving us itimani njengo Lora siyabonga Lora kakhulu ukuthi please
Lola.
buy Rata ngisasho ukuthi yini but yes,
I'm not gonna buy Rata anything.
we are going to buy
I'll buy tea.
buy tea. Yeah.
I'm a tea lover.
I love history. The judges and the magistrates in the medieval period were lords, and as the British title, they were not lords because they were in the judiciary. It was their title. So we adopted that. Can you imagine? And indeed.
And then now they're no longer using that my lord in their courts. Britain is not doing that.
We call each
Even
other
the
Lord
wigs.
Bradley, Lord Banban.
Even the wigs. There are some African countries that are still wearing those hideous wigs.
It's Nigeria, to be specific, that I've seen.
They should get rid of those wigs.
It just
They need to
doesn't
ban
make you're
them.
wearing a white thing in your head. How is that representing us as
So my lord must go,
black people?
and then the wig thing must go.
Mm.
Then
As
we'll
it-
think about the robes, because even in the States, they don't wear robes anymore.
Asithi Boni Bekwayo, thank you also. for the tea money. Thank you. We appreciate you.
Thank you.
I
drink tea now. I'm getting old.
Yeah, yes, we are witnessing that. How can he code wrong cases twice? It was the way of assisting BALOYI to close his loopholes. Indeed, and the record captured that there were cases that were submitted.
They need to highlight. You guys need to start collecting this. The date was the 7th of November.
Njomane.
7th of November.
Siyabonga kakhulu Njomane. Pink Ndlovu siyabonga. Ukuthi ubukhona la backyard mechanic at the Good Morning Comrades. Great submissions by the defense. Indeed, backyard mechanic. Brilliant indeed. Mrs. V at the Good Morning. Siyabingelela Mrs. V. Edward Njamba at the Good Evening team. The defense nailed it, and Umalo just informed the judge that you listened, but you don't. When he read the record of Zungu, siphume njalo siye lapha phansi ke siyobonga na imali yetiye na imali kagesi na imali yetiye mawutwana Africa jabati uNkulunkulu abusise la uthathe khona siyabonga yeah. Calls are 071 153 7006. That's the number that you call for WhatsApp, for calls direct. But since we're 18, awusiyabonga. Lama week uthi uhleka lento yama week. Lento yama week nama ngi understand ukuthi why is it still there? It doesn't make sense. They are a symbol of white hair. Like and
they're ugly on top of everything.
And you are wearing them on top of your hair.
And then you find black women, we like our wigs. She's wearing her wig, and then she's wearing that wig.
You're wearing two stuff now that are not your hair. Hey, madada. Umlungisi akasibone lapha. Umlungisi Jonas. Siyabonga Puleng Senkhane. Good morning, family. Good morning, Puleng. Chris Neo, Nebs, I've mentioned you. Boni Bigwayo, I've mentioned you. Thank you. Mlambo Designs at hello. Raul Mtrobel at the Good Morning Zanzi family. Morning. Mampo Ramete at the hey guys. Lazola Boyo at morning. Lindiwe Bam, our member at the Good Morning family. Thank you, Bonik. Yes, Bonik. Besingazi silbiza hlikama bekshanje uboni bese ngibekwa. Ufeya N7M Molweni family. Mayane ndanganeni, sorry. Judge Rata cannot hide his biasness, and we are witnessing that too. And he was caught between all it's alleged. Right. Didi Talks at hello. Tobeka D at the Good Morning. Sizwe 18 ukhona sephinda futhi. Umbali Bembe at Molweni family. Molo Mbali Lindiwe at Hey family. Sipogazi Lungani member lena at Morning family. Yeah. Injalo indaba Mbuso Zibula. Uti good morning Mzansi Reality family. Good morning Mbuso. Crash at good morning Emily and Mr. Ano and family at large. Sibonga siyabonga Crash. Siyawubona na siyakubona. Tembelani Kanye at the evening Mzansi Reality family. Sehla njalo sizobamba untokozo Mbele at Good Morning family. Siyabonga lapho untokozo. Sibone futhi ubani omunye simbamba Chuku Ana Chugwana, thank you very much for being here. Pedro, good evening, lovely family. Morning, Pedro. Morning, Pedro. On our side is the morning side. It's a morning. Ndanzi, good evening. Good people. Yabantu bapesheya madoda. Sithi nje morning la South Africa, Africa. Africa burwa. Yeah. Mbuso, okay, Mbuso, I've mentioned you. Ntsikelelo Mkehle. I was worried about it. About Miss yesterday, but he came back stronger today. Indeed, I mean, it was uncalled for what happened to him also. Mzansi, hello. Mzansi, hello. Mzansi.
Morning. Good morning.
Hi.
Good morning.
Hi, how are you?
Yeah. I'm good. It's unfortunate that the judge couldn't give a judgment yesterday, but I think he still needs to go and, this is alleged, please take note. I think he still needs to go and confirm how much is still left in his own envelope from the cutting call from Serbia over this case, so that these guys can be convicted. So you can't just give a judgment without consulting to see his judgment is it worth the money that is still left from the cutting got from Serbia. So yeah, expect something to surrender on Monday after it's confirmed that. And remember when the judge came in, he used to talk of the tavern and all that issue of the golf, where he said, I go play golf, I go and drink in the tavern. And in which I once called and said, no, the judge is giving highlights of where to get him when you want to give him a brown envelope. So, to me, I think the issue is he's actually meeting up with BALOYI over the weekend in one of these two places. Don't be surprised when on Monday he comes, he will give BALOYI, ask BALOYI if he has anything to say before he gives a judgment, so that he can give him leeway to slot in 2 or more cases reference to sway his judgment. But already the judgment will be there, so they would have discussed it over this weekend. That's my alleged thinking. So yeah.
Allegedly.
Yes. So yeah. Yeah. That's why I find he was allowing BALOYI for the past 3 weeks to ask the same question. The past 3 weeks and never intervened. Because the judgment is already written. All they want is something that pretends to be evident for them to say, yes, the judge did. But right now, the way CBI has stood is has been solid. He has denied everything they can prove. And worst of what unsettles me is CBI is constantly saying, no, that is not my name. In short, CBI was telling the judge, you guys, you are trying me as the wrong person. I'm not the same person in which the police wrote. And furnishing the police said this ID that they only released last year, but they still couldn't write his name properly, which means these confessions were actually written in the bar, not at the police station. Because if they had written them at the police station with this ID in hand, they should have wrote everything correctly. But because they didn't write them in the office, so they misspelled a lot of things. Wrong address, wrong name. I think if I was the judge on that pretext, this case should have been thrown away. Because how can you write a convict's name wrongly when you have got him in your custody with his official documents? So yeah, I don't know. Let's see how it goes. But yeah, I feel sorry for these 2 innocent guys that already their name has been tarnished they've lost 4 years, more than 4 years of their life
6.
of a thing that they didn't do. Oh, as I said,
6
6 years plus. And remember, it's still going. So I'm saying 6 years plus until the case comes to an end. Yeah, I wish people could be human. I think right now is the time where a GoFund will be needed to try and make sure when these guys if ever they're not convicted, they will need to regain their life, and the GoFund for them to start somewhere in life would work. But being Africans, we're so individualistic. Everybody wants to be seen as a boss. It's what it is. Yeah. But have a good weekend. Enjoy your weekend, guys, and continue to do the good work. And I've got one thing that you guys, when you started, you used to translate whatever comments that were critical, that were putting in vernacular language, you translate them into English for your other international followers.
Of the phone calls. Of the phone calls.
But of later, you no longer do that.
It's because we don't see the comments that are requesting for it to be done. Usually when we did it would be because people were saying on the chat, please translate.
No, you guys have got, remember, you've got following people phoning from Australia, from all those places. Who are not even, some of them are not South Africans. So just keep that in mind.
Okay, I will try. I will pull up my socks.
I'm not saying you need to translate everything, but there are some that are critical, some information that you think this makes much sense.
Okay.
I think that is what is worth translating, not just everything. No,
right.
That's too selective.
So you feel thank you very much. Have a
great weekend.
Thank you.
All right. Thank you.
Thank you.
Okay.
Thank you
Bye
very
for
much. Now. Yes. That's it from my side, Emily. Sabonga, cool. From all the callers that called in, everyone that participated, liked the video. Please do, if you haven't liked the video, and I see many people saying, oh, I saw Rita here saying, hey, I should go to radio. Yes, I'm going to go there. I'm living Mzansi reality. I'm going to live Mzansi reality. What can I do? I'm being called somewhere else. Then I'm going to leave you alone.
He's a broadcaster.
I don't know, but here I am at Mzansi where it all started, and
I also forgot to tell, also to note about what had happened more towards the end, where the judge was saying that there's another judge that he talks to from the Constitutional Court who's working and is sitting on a judgment. He hasn't yet handed over the judgment, but it deals with what is happening with this application, BALOYI. So I forgot that, but I found that very interesting.
We don't care. All at this point in time, all we are saying is that Mzansi, hello.
Hello.
I say, how are you?
I'm good, man. Yeah, I'm speaking to Bong from Cape Town.
Yes, Bongs.
Yeah. You see the situation now. It's the explanation of Induku. Doesn't weird.
Yeah.
You fought so hard for these statements to be admitted as confessions. Now the statements are admitted. Tiki, you change. No. They must also be treated as executive statement. It can be only in Dogo in the land.
Yeah.
It's in Dogo. Let's not beat around the bush. There is only explanation when the land in Dogo. The guy can realize he's fighting a losing battle. Nando. Nando. And I'm also suspicious, man, about this reserve judgment. There is no reserve judgment. There is only a matter of going to research cases to justify the nonsense you'll come up with Monday. You need weekend to go do your research. You can't say this thing is straightforward compared to the situation of Zungu. If you remember when they said Zungu is going to KZN to look for some stuff, we had the written, and before we could even hear Zungu if man knows KZN or not. But this one is pertaining the law. You know what the law stipulates regarding this situation. But we need whole weekend. But Zungu, the whole weekend were ready drafting your judgment before you could hear from Zungu. Chief, did you find your notes or not? Already have a written judgment. This one is big complex because you need to justify it. It's not like you don't know what you're supposed to do. You know what you're supposed to do. You are just trying to justify it. But one thing I like, man, let's keep praying for the guys in the Meyiwa family.
Yeah.
Let's keep praying, guys. You see now, all the things are coming to light. I like what's happening with the Auto Committee and the Madlanga Commission. The names are dropping there.
Yeah.
The chief is of Kininda being the man of integrity and all that stuff. We are hearing their names with some shady dealings. With some characters there by the Madlanga. So everything, like even Tefu is being vindicated. If you remember what Tefu said to your show, he said, when you know a lot about these things, people who don't know, they will look like at you like you're a fool.
Yes, like you're quack.
Yeah, exactly. That's what Tefu said. If you remember, you hosted Tefu.
Yes,
after that disrespect. I still every time I would speak, man, I can't help but I think about Miss Emily and Mr. Arno and Mr. Tefu. And he told us, when you know a lot about these things, South Africans look at you like, this guy is a fool. What is he talking about? But now they are coming in right in front of us. The issue of which Mr. Arno is in Kenya. You remember the guy who was once invited for dinner by the FF or something, Prof. Lubumba.
Yeah.
He's the only advocate. He don't wear that thing. And there was a judge who was pulling rata stance on him. On the wrong guy. You don't mess with Prof. Lubumba with African culture and how the law should be.
Yes.
He's the only guy who don't wear that nonsense in Kenya. All the senior counsels who were there. He told them straight, no justice. Where is this thing coming from? Who came up with it? Why should Kenyans senior counsels? He even said, why should Kenyan senior counsels wear this nonsense? His Prof. Lubumba was questioning that thing right in High Court in Kenya, where there was a riot, students were fighting for something. He was representing students from some of the university there in Kenya.
Wow.
I follow a lot of Pan-Africanists. That's why I like Moses so much. I know people who are talking African language. Is Prof. Lubumba, Advocate Kakane, and the other advocate there by Kenya, his name is Keita or Isaiah Kato, something like that.
Okay.
More like, if you remember, the guy who was KEF president for a long time.
Yeah.
This senior counsel, the name is similar to that guy. And Prof. Lubumba. Here in South Africa is Moses Kakane. The rest of advocates, when you say this pretend law and all that Dutch laws, you impress them. You don't press Prof. Lubumba with these laws because they know this thing is nonsense and it's not ours. And they don't hesitate to put it out. It's 3 advocates. Here is only one, Moses Kakane, Prof. Lubumba, and this guy. It's either Keita, but he's also from Kenya. He was there on the bench with Prof. Lubumba.
Yeah.
If you remember
I
when
think I
he
know,
was,
it's just that I forgot his name. But I think I know
yeah,
what you're
he's
talking
always
about.
Prof. Lubumba. He's always with Prof. Lubumba there by the
Yes.
High Court. Kenya.
Yes.
You will can see their video. You will see this is the guy Bongs was talking about.
Mm.
Yeah, exactly. This is the guy who was questioning this. They don't wear that nonsense. All the ladies, as Miss Nelly said, they wear wigs and still put that nonsense. Prof. Lubumba doesn't wear that thing. There are two in Kenya. They don't wear that thing. All the justice, your my lords, they can't do anything. Prof. Lubumba doesn't wear that thing. He once told the other judge, now it's too hot for me to wear this nonsense.
Can you imagine Prof. Lubumba with that wig? Oh my God. No, it's a no. No from me. No. He made a good decision.
Yeah, we lost you. We lost you there, Bongs. But
Bongs? Hello?
yeah,
Hello.
we lost you there. But yeah, thank you.
Okay, Bongs is gone. Thank you, Bongs. Thank you.
Right, Buffett, Asival.
I see Valin, guys. We'll see each other next time. Next time is a safe
Tell him
word.
to semi-fallen from Nigeria too. Semi-fallen from Nigeria.
Yes. I think that's the one that he was referring to, because Nigeria, they also wear those wigs, I think. I don't know if it's all states, but some of the states, they do put on those wigs.
Yeah. Good. Let's press the like button one more time. And yeah, it's a bye from us.
Bye, guys. And thank you so much for watching. We'll see each other again next time.